Welcome to Panel 1 of Justice Thomas's 30-year legacy on the court, Safeguarding the Structural Constitution, Federalism, and the Separation of Powers. Please welcome our host, John Malcolm, Heritage's Vice President of the Institute for Constitutional Government and the Director of the Meese Center for Legal and Judicial Studies.
Well, welcome everybody to the Heritage Foundation. On behalf of Heritage and the Gray Center at the Scalia Law School, we are delighted that you are here for this very important occasion. I would remind people when they're here in the auditorium, please wear a mask, and also we would very much appreciate it if you would check to silence your cell phones ahead of time. We are so happy that you are here to help us celebrate with this all-day symposium the occasion of Justice Clarence Thomas's 30th anniversary of his confirmation and appointment as an Associate Justice on the Supreme Court. I hope you will agree that we have an outstanding series of panels exploring Justice Thomas's impact on the court and on the law. We're going to get right to it. The moderator of our first panel is John Yoo. John is the Emanuel Heller Professor at the University of California at Berkeley Law School. He is a prolific author and commentator. He served as a Deputy Assistant Attorney General in the Office of Legal Counsel at the Justice Department during the Bush administration, and he also clerked for Judge Lawrence Silberman, whom we will be honoring later today, and for Justice Thomas. And with that, John, I turn it over to you.
Thank you, John. Thank you, everybody, for coming today. I'd like to thank John Malcolm for putting me on the schedule at 8:30 in the morning after I flew from California. It's 5:30 my time. It always does this to me. This is the revenge of the Civil War reenactors upon us out in California. I also congratulate the Heritage Foundation for your new president, who was just announced this last week. And you might have heard this very nice jazz music while we were coming in. I assume that's all going to be changed to banjos and other kind of Texas music for all the internal heritage music systems. And I also want to thank all the judges here who are participating. It was I was expecting when we were organizing this panel that it would be extremely difficult. Not having been a judge myself, never having sat in on a judicial conference, I expected them to make demands, yell, scream, but they were all so accommodating and cooperative. This was not what I thought judges were like at all. So we've got a great division of authority.
Is this a statement about Larry?
I got Silberman later, don't worry. And so you all know who they are. I'll just introduce them all very quickly. And then I thought before we got to the substance of it, ask them to share any story or encounter with the justice that they had over their years on the bench. So all the way on the far left, Judge Tom Hardiman from the Third Circuit, my home state of Pennsylvania. Next to him, Judge Naomi Rao. I call her Naomi because she's younger than me. Judge Naomi Rao from the D.C. Circuit. Judge Youth Jones from the Fifth Circuit, and Judge Bill Pryor from the 11th Circuit. So, Bill, why don't you start? Do you have any, before we talk about the substance, do you have any story or?
Yeah, so I think the first time I spent a meaningful amount of time with the justice was in a visit to Tuscaloosa, Alabama, to the University of Alabama Law School to give the Albritton lecture. Harold Albritton is a federal district judge in Alabama, and he is just, I think, 4 or 5 generations of Alabama lawyers from the Albritton family. And they have a lecture series that almost every justice of the court has participated in. And the justice came down for that visit, and often they schedule it in conjunction with a football game. Surprise, surprise. And that weekend was the Alabama-Tennessee game. We refer to that as the third Saturday in October. And it doesn't matter that this weekend is the fourth Saturday in October because Alabama and Tennessee are playing, so it's really the third Saturday in October. And the bad news is, Justice Thomas is quite a fan of college football. He regaled us with stories the night before about his love of NASCAR. But he arrived at Bryant-Denny Stadium, and he's a Nebraska fan, for those of you who don't know it. And Nebraska had, as they have been having now for quite a while, a tough morning. They had played the 11 o'clock game against Iowa State, and this was before Iowa State would be ranked. And Iowa State had beaten Nebraska. And I would say he was not in the best of moods when he arrived at the stadium. But it was remarkable to see his interaction with people at the stadium, and particularly just restaurant, cafe type service workers, but also members of the board of trustees of the university. And everyone wanted to meet Justice Thomas, have their photograph taken with Justice Thomas, chat with him about the day and the game. And he really loosened up pretty quickly. This was 2009, this ended up being a really close game. This was Coach Nick Saban's first national champion season at the University of Alabama, and an undefeated season was on the line. Lane Kiffin was the coach at Tennessee, and it ended up coming down to a field goal on the last second that Alabama blocked. And by then, it was remarkable to see the justice's transformation through the afternoon. He really got into it. I mean, he was totally into this very close back and forth game. And when Alabama blocked the field goal to end the game, what is known back home as Rocky Block, the stadium erupted, and it was just pure joy on his face. And this was, to me, captures the real Clarence Thomas, really, in so many ways, such a regular person, genuinely warm person who has a love of life. He was so popular with so many just regular Alabamians who were so honored to meet him, and who he met and made every one of them the center of his attention as he met them. So it was really a terrific beginning to what has become a great friendship.
Good. Having gone to college, I didn't know football was played at the collegiate level. This is very interesting to me. Judge Jones.
I don't talk football anymore. Well, there's not much to say. After my father spent every weekend glued to the football games, and he died before before the Southwest Conference failed, and therefore a year later there would have been no Texas versus Texas A&M Thanksgiving game, and had he not died, that would have killed him. So that was the end of my interest in football. So I can't talk about that with Justice Thomas. I will be briefer than Bill because I think I met him when my law clerk, Greg Coleman, was in one of his early classes of law clerks, and you all may know about Greg. And I came up to invited myself up to visit Greg, and the justice ushered me into his office, and we started talking. And what is an introductory conversation with him often turns into at least 30 minutes. Yeah. But in the ensuing years, we've had a number of those conversations. And I agree with Bill. The thing about Justice Thomas is what you see is what you get, and in fact you could call this jurisprudence, the jurisprudence of what you see is what you get. I love him to death. I love Virginia. I love their stories about traveling around the country in their RV, where they stop often at a parking lot of a Walmart or a Home Depot or something, and there are a lot of other people there in their own RVs, and nobody knows who he is, which doesn't bother him in the slightest. One problem we have nowadays is sort of that some judges would rather be personalities than judges, and that does not characterize him. And I'll say one other thing. I had the privilege of attending Hillsdale College when they inaugurated their new chapel a couple of years ago, and he gave the inaugural address. And if you're interested in gaining a real insight into the mind and soul of a man who believes deeply in God, as well as in the Constitution and the American system, I urge you to read his inaugural address for that chapel. Thanks.
Great. So I first met Justice Thomas when I interviewed with him for a clerkship, unsuccessfully the first time. So that was the first time I had the opportunity to meet Justice Thomas, but it all worked out in the end, in part because I was working in the U.S. Senate and saw the justice in the cafeteria, and eventually that led to a clerkship somehow. But I don't know, I definitely don't have any football stories with the justice, but having been his clerk, really one of the greatest privileges of my life to clerk for such a man and such a jurist. He has taught me so many lessons about not just the law, but about how to be a great person in the world, watching him interact with his colleagues, but with everyone in the courthouse, from the person in the cafeteria to the man rolling the books into chambers, to the woman, running the elevator, because the Supreme Court still has people who run the elevators. It's a real lesson in humility and in life. So for me, it's been one of the most significant relationships I've had in the past 20 years.
And Naomi and I share that. We both interviewed with the justice and were not hired, but I did not stalk him in the Senate to get the job.
Hey, I was just minding my own business, eating a tuna fish sandwich or something.
Well, everything my colleagues have said about Justice Thomas being a regular guy is certainly true, and there are thousands of stories to that effect, and I have many from when he came to Pittsburgh, and I had the privilege of being one of his interlocutors at Duquesne University. But the story I want to share with you is in the category of the things people never hear about Justice Thomas. And I think they've heard more and more about how he treats every human being with dignity and respect. But this was a very special trip that we took to Washington. Actually, Judge Dick Leon was visiting Pittsburgh, and he was looking at some photos in my chambers, and he asked me about a particular photo. And I said, well, that's my little brother through the Big Brothers Big Sisters program that I've been involved with for many years in Pittsburgh. And he said, oh, well, tell me about him. I said, well, one thing you'll like, being a Holy Cross guy, is he's a big fan of CT. He said, oh, really? I said, yeah, you think there's any chance I could get him an introduction? He said, let me work on that. So I got a phone call from Judge Leon, and a few weeks later, my little brother and I were on our way in the car from Pittsburgh to D.C. We watched 2 oral arguments, and then my little brother got an audience with someone he really admired, whose autobiography he had read a couple of times. And of course, I assumed it was a 5-minute photo op, shake hands, wonderful, good to see you, but no. He sat us down, and about an hour and 20 minutes later, he said, well, there's a dean of a law school out there, and I was supposed to see her about 50 minutes ago, so I think you guys better get moving. But it was one of the most extraordinary and profound meetings I've ever seen, the way he got to know my little brother, the way he listened to him, the way he counseled him and advised him about the challenges he would face growing up in this country. And it still really moves me to this day. And respected the justice for many, many reasons, but that one's very high on the list.
Thanks, Judge. Well, let's start on the substance of the program. So instead of direct presentations, we discussed this and thought we would have more of a conversation. So each of the judges has agreed to cover a certain area of the justice's jurisprudence, and I would just introduce the cases so that they didn't have to, and we could hear their thoughts, and then hear what the other panelists have to think about the justice's opinions in this area. So maybe what we could talk about first is Justice Thomas's longest opinion. So that would be his dissent in U.S. term limits versus Thornton, a 5-4 case where the Supreme Court struck down state efforts to impose term limits on federal representatives to Congress. Justice Stevens wrote the majority opinion, and Justice Thomas wrote the lead dissent. Judge Jones, do you want to start off with that case?
Yeah, well, when John assigned this to me, I hadn't read the case lately. Maybe I never read it at all because, frankly, I don't read some of the Supreme Court cases that I don't think I'm ever going to have to deal with because they're so darn long. Well, it turns out, John giggles, this was supposedly the longest opinion that Justice Thomas has written. So I kept reading and I kept reading and I kept reading. Of course, it's long because it's full of substance. And I am borrowing a couple of my thoughts here from Professor Ralph Rossum of Claremont, who I met years and years ago at a judicial conference that was later outlawed, called Understanding Clarence Thomas. He wrote a book, Understanding Clarence Thomas, The Jurisprudence of Original Meaning, which is a very thorough rundown. But the basic idea of Justice Thomas's dissent in U.S. term limits is that the 10th Amendment, which says that all powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states or to the people, that the 10th Amendment should have allowed the states to add certain additional qualifications for members of Congress. As you know, Article 1 says that the only qualification for Congress is that a person be at least 25 years old, a citizen of the United States for a period of time, and a resident, an inhabitant of the state. And the question in the case was whether the people of Arkansas validly enacted a state constitutional amendment that said that if a person had been in Congress more than, I think it was 3 terms, that if they wanted to stand again for that office, they had to do it by write-in ballot. In other words, it didn't really take them off the ballot. It said that the voters had to deliberately choose them. 5-4 decision. Justice Stevens goes into original meaning at great length. Justice Thomas goes into the original meaning of the 10th Amendment at even greater length. I think the principle, he starts off with a textual exposition of the 10th Amendment. What does it mean to say that the people ratified the Constitution of the United States? Justice Stevens's argument is predicated on, well, this is by the people, ratified by the people, and therefore these qualifications are exclusive to the Constitution and may not be interfered with by the states. Justice Thomas takes this on directly, talking about the people of the states ratified. It was people in the states that ratified and did not give away certain of their powers. As he puts it, the federal government and the states face different default rules where the Constitution is silent about the exercise of a particular power, that is, where it does not speak expressly or by necessary implication. The federal government lacks that power and the states enjoy it. And then he goes on to talk about what are reserved powers. I could spend quite a long time summarizing his opinion. For the sake of the discussion here, I won't do that, but I will point out a few things. First of all, he wrote this in '95. He had been on the court only 4 years. It is a tour de force about original meaning. Second, it is a very, very difficult argument from the standpoint of the dissent, because one would think offhand, surely, when the Constitution states these qualifications, obviously, those have got to be the only qualifications for representation in Congress. Third, he takes on Justice Story, one of my favorite former justices of the Supreme Court, who said unequivocally these qualifications had to be exclusive. Fourth, he takes on the idea that the idea behind what Justice Story said was if they're not exclusive, then states could undermine the very principle of representation in Congress in two ways, either by setting qualifications so high that effectively they weren't participating in Congress because they couldn't elect many people, or by setting them so high that they were moving back toward an aristocratic or oligarchic conception of the office holding, which is what the framers in part were trying to avoid. So it's not the easiest argument to make, but I will say he does a magnificent job. He also has to take on the the language of the qualifications clause, the argument that, quote, democratic principles lay behind this argument for exclusivity, and then the weakest argument of the majority, which is historical evidence, because in fact, at the time of the framing, several states did have additional qualifications for service in Congress. And in fact, if the qualifications stated in the Constitution are exclusive, then a state can't bar a felon from serving in Congress. Not that that hasn't happened before, but they can't literally prohibit it. So I would introduce this as one of his earlier opinions, stating forth what Rossum calls a jurisprudence of original meaning, which takes on first the text, then the context, then the way in which the provision was structured at the time of the framing in order to elucidate its meaning, and then the naive notion that, gee whiz, the way the original meaning at the time of the Constitution is the way it should be applied today.
Any other comments or thoughts? I remember at the time people criticized the Thomas opinion as perhaps being too anti-federalist. There was this idea, well, if Justice Thomas was right, does that mean states could instruct senators how to vote and really take over, interfere with federal officials? What do you all think of that criticism of the dissent?
I think there's something to be, well, this reminds me of, and this isn't about me, but I had only one senator in the room when I had my confirmation hearing, and that was Strom Thurmond, and he said, young lady, that was not controversial like some.
And some who didn't learn their lesson and continue to be so.
I don't speak ill of the dead when I say he asked me the question, young lady, what do you think is the role of the 10th Amendment? And at that time, 1985, having litigated only a couple of constitutional law cases and an otherwise career devoted to general litigation and bankruptcy law, I said, well, sir, the Constitution gave certain powers to the federal government, and whatever it didn't give to the federal government were retained by the states. He said, young lady, don't you really mean that the states gave few powers to the federal government and all the rest? I said, oh yes, sir, you're right about that. And I do not think that that is the theme of this. The only way in which I think you could fairly make the argument that John is saying is by somehow saying that the idea that the people acting in the state ratified the Constitution somehow means that you have, overweening state authority. And it's very amusing. He starts out the dissent by saying it's ironic that the court bases today's decision on the right of the people to choose whom they please to govern them, when in fact this measure had been adopted by a state constitutional amendment. And later on, what is the other case I was looking at? In the voting rights, in one of these later, more recent cases where the voters, it was the Arizona Independent Redistricting Commission case. You have a 5-member majority of the court saying, Arizona adopted this Independent Redistricting Commission as a matter of a ballot initiative, and therefore this is entitled to the highest deference. And the argument, of the dissent was Article 1, Section 4 says congressional districting must be done by the legislature. So it was in flat contradiction to the Constitution. And Thomas, in his dissent, says, well, it's very ironic that they're talking about deference to ballot initiatives here when they're not paying any attention to them in things like term limits, abortion, the sanctity of marriage, and so on.
Judges, any concurrences or dissents? No? No. Okay, let's move on to the next federalism topic with Judge Hardiman, who has agreed to talk about 2 cases, United States versus Lopez and Gonzalez versus Reich. U.S. versus Lopez was about the conviction of a child who brought a gun to school in violation of the Federal Gun-Free School Zones Act. At the time, of course, the New York Daily News, with its usual scholarly acuity on the front page, said, "Case of pistol-packing Pee-wee makes it to the Supreme Court." And in that case, the court 5-4 struck the law down as beyond the Commerce Clause. Justice Thomas wrote a concurrence. And Gonzalez versus Reich is a 2005 case where the court, I think to the surprise of some, upheld the Controlled Substances Act in a case where one person grew marijuana at home, gave it to another person. Believe it or not, this case, the facts of this case arose 4 blocks from my office in Berkeley, California. Who would have guessed? However, in that case, the court, by a 6-3 majority, held that the Commerce Clause could reach the gift of marijuana because in the aggregate, it had a substantial effect on interstate commerce. Justice Thomas wrote a dissent. So, Judge Hardiman?
Sure, thanks, John. Like the case Judge Jones presented, Lopez is, we could say, early Justice Thomas, 1995. And one observation I'll make, I think, is that I didn't notice it at the time, certainly, and perhaps few did, that this was a sign of the difference between Justice Scalia, who I think called himself a faint-hearted originalist, and Justice Thomas, who I think we could say is certainly a full-throated originalist. So here you've got Justice Scalia joining Chief Justice Rehnquist's opinion. So he and Justice Thomas were on the same side in this case, but Justice Thomas writes the concurrence, as John said, and Justice Scalia doesn't join it. There were many other times where Justice Scalia or Justice Thomas wrote separately, and they may have joined. But here, Justice Scalia doesn't join Justice Thomas's very textualist, very originalist concurrence, which is essentially a critique of the substantial effect notion that anything that has a substantial effect on interstate commerce is regulable under Article 1, Section 8 of the Constitution. And in that concurrence, Justice Thomas said that we've said that Congress may regulate only commerce among the several states, not only commerce among the several states, but also anything that has a substantial effect. This test, if taken to its logical extreme, would give Congress a police power over all aspects of American life. And that's a theme that he's returned to again and again, and he returns to it in his shorter separate dissent in Gonzalez versus Reich. He's expressing this concern that if we read the Commerce Clause power so broadly, as the court has read it since the New Deal cases, according to Justice Thomas, it would give the federal government unlimited power. So right away, he's staking out this structural concern about the balance of powers between the federal government and the state governments. One of the quips that he makes in the Lopez case is that it seems to him that the power to regulate commerce can by no means encompass authority over mere gun possession any more than it empowers the federal government to regulate marriage, littering, or cruelty to animals throughout the 50 states. And again, it's consistent with that theme. Years later in Gonzalez versus Reich, he talks about other very local activities, including quilting bees and a couple of other very local activities that everyone would say, well, what does this have to do with interstate commerce? And the image that came to mind as I was reading these cases again was sort of the wings of a butterfly idea, or the ripples in a pond. That's really what he's pushing back against here, is the notion that if you take any one thing and aggregate it, it can result in a very serious effect. But that's not the way we should be looking at the Commerce Clause. Interstate commerce is something that's qualitatively different, he also says. This is a very important originalist point he makes. He goes back to founding era dictionaries and the debates at the ratification, during ratification among the states. And those debates indicate that the Federalists and the Anti-Federalists saw a distinction between commerce on the one hand and agriculture and manufacturing on the other hand. And if Justice Thomas is right about that, then what does that say about Wickard v. Filburn, for example? So he makes this distinction between transporting goods and selling goods, trading across state lines, which is right within the heartland of Article 1, Section 8. And on the other side of the equation are agriculture, manufacturing, producing things out of the ground or in the factory. And that's qualitatively different than commerce. It doesn't become commerce until it starts to get moved interstate. So that's a very important sort of first principle argument that he staked out very early in his jurisprudence, and it's certainly continued consistently over his 30 years on the court. And again, another important distinction in Gonzalez v. Reich is Justice Scalia is now against Justice Thomas, right? So in Lopez, they're together on the result, but not together on the ratio. But in Gonzalez, they're against one another. And I've often wondered, one of the questions that I wish I could have asked Justice Scalia in private was, if Reich had a couple of grapes in the backyard and was making her own wine, would you have come to the same result? I don't know. But Justice Thomas, clearly this was a bridge too far for him. His dissent in Reich is really not focused on Article 1, Section 8. If you read his dissent, which you really should, he only very briefly addresses that. He sort of gives it the back of the hand. He says, this obviously is not interstate commerce. He spends the great majority of his dissent engaging on the necessary and proper clause. So that's really where the battleground is there. He explains why he disagrees. And Justice Scalia's separate concurrence in Reich focuses on necessary and proper. So you've got a great debate between Justices Scalia and Thomas about how much work the necessary and proper clause can do in service of the Commerce Clause. So these are two really wonderful opinions that you could sort of keep coming back to and never, at least for me, never get tired of.
Just brings a question to mind for all of you as judges. What do you think about the Justice Thomas's approach to precedent? And neither of these opinions really seem to pay much deference to the decisions of the past on the Commerce Clause. Does that make his opinions sort of these quixotic pleas to return to the original understanding that really don't have much chance because they are so sweepingly dismissive of precedent, or do they really have an effect?
Well, one thing I did notice on that issue, John, is that Justice Thomas drops a footnote in Lopez, which is, I think, a response to the notion that he's trying to just upend the apple cart completely. What he's saying is we need to re-examine our Commerce Clause cases. And he says something about, what do you do with 60 years of jurisprudence? I'm not sure. You just overturn it. And when I read that in preparation for this, it seemed like something he wouldn't write now. But I think, Judge Rao would have perhaps more insight having clerked for him on that, or you, John. But that's sort of step backwards. And he mentioned stare decisis explicitly in the footnote. His more recent opinions, I'd say the last 10 or 15 years, I'm not sure that's a step back that he would take these days.
I guess the most significant opinion he's written on his view of stare decisis was pretty recent. And to me, everyone says, well, Justice Thomas doesn't believe in precedent. And it's not exactly right or fair. He thinks what we take an oath to uphold is the Constitution, and it's the Constitution that's the ultimate touchstone, and that's what matters first. But if you want to look at a fairly recent example of where precedent makes a difference to the justice, look at the Gamble decision. And Justice Thomas had been one of the early skeptics of the notion that the double jeopardy prohibition would allow a state to prosecute someone for an offense, have that individual acquitted, but then a separate sovereign, the federal government, could prosecute that same offender for essentially the same conduct. And then the court decided to re-examine extremely settled, long-standing precedent about just that. And at the end of the day, the court stuck with its precedent. And there was Justice Thomas in the majority. I think it was 7-2 was the final vote, with Justices Gorsuch and I think Ginsburg in dissent. And Justice Thomas, looked at it and said, now that we've had that opportunity to examine this, there are good arguments on both sides, but I can't say that this is demonstrably erroneous in the language that Caleb Nelson scholarship, introduced to us all, and he stuck with the precedent. So it's, I think in that's in keeping with the footnote that you read, Tom.
Go ahead.
I do think Justice Thomas's views have become perhaps a little bit less favorable to precedent over time. I mean, he says in Seal of Law, I think he says something, he says, we simply cannot compromise when it comes to our government's structure, he says, in calling for overruling Humphrey's executor. But I think his view, to Judge Pryor's point, I think his view about precedent is more nuanced than people often think. Precedent is often a source of collective wisdom over time. And I think Justice Thomas does not have so much hubris to think that in a few months he can always rethink the whole Constitution. And I think that is what's reflected maybe in some of those footnotes or other places in which he sort of suggests, we need to think about the precedent, but what we always need to have fidelity to is the Constitution, which is, of course, what we as judges take an oath to uphold.
Yeah, I think you can see that he takes most issues step by step over a period of years. And a good example of that is his opinions in the Voting Rights Act area, where in 1999, in one of the Voting Rights Act cases, he said, just remember, Section 5 of the Voting Rights Act, which required pre-clearance for every single change that a state or municipality might make in a voting regulation, had to be pre-cleared by the U.S. Justice Department. He said, just remember the huge federalism costs that exacts. And then a few years, it was finally 10 years after, then in the Northwest Mud case, argued by my former clerk and his, Greg Coleman, the court gave a minimalist ruling, and Thomas files a concurrence saying that we really should have ruled on whether Section 5 is constitutional at this point in time. That case was 2009, and then in Shelby County, just a few years after that, the court said, well, and picked up most of the things that Justice Thomas had said in his concurrence in the Mudd case, and said, well, now we say that the coverage formula, which is Section 4 of the Voting Rights Act, is in fact unconstitutional. Section 5 is looming out there to be reinstated if Congress decides to apply preclearance, say, across the entire United States, and then we'll see how far the Fifth Amendment goes. But he points out he wasn't making a full exposition about Section 5 in 1999, but 6 years later he was ready to do that, and that argument is still out there because, sadly, whatever you allow Congress to do, it probably will do someday. As far as the Commerce Clause dissent goes, that is a very important dissent just to remind us how far the powers of Congress have strayed from what many of us, including Richard Epstein and myself, think was the original scope of the commerce power. But in the Turkle case, not Turkle, it was Turkle in my court, AAR case that seems to have resolved the eviction moratorium issue, this line is thrown off. It's just a stay decision, so it's not a definitive decision. It was a 5-4 stay where the Supreme Court took up a DC court ruling and said, we're not going to dislodge the decision of the district court to overturn the eviction moratorium. And they said, but of course Congress could have imposed an eviction moratorium. And just think about that in terms of the fact that the moratorium did not prevent landlords from collecting their rent, which would have been arguably a commercial aspect of the transaction. It prevented them from going to court because the essential terms of the real property lease had been terminated by the tenant's failure to pay rent. So it was could be a very consequential imposition or expansion of the Commerce Clause, just like one might say, not commenting on current other health measures that people are proposing.
Judge Hardiman,
Yeah,
did you
just
wanna
one
make more point?
follow-up, consistent with what Judge Rao said in a 2004 concurrence, in a federal bribery case, Justice Thomas wrote that Title 18 U.S.C. 666A2 is a valid exercise of Congress's power to regulate commerce, at least under this court's precedent. And then he said, I continue to doubt that we have correctly interpreted the Commerce Clause, but until this court reconsiders its precedents, and because neither party requests us to do so here, our prior case law controls the outcome of this case. So I think that's a great example of Justice Thomas's approach to judicial restraint. One of my pet peeves is when I call it an opinion in search of a case. A pet peeve of mine is when judges have these opinions and they just want to write them because they have something important to say and they forget the case or controversy requirement. So I think it's telling here that Justice Thomas is saying the court has not agreed to reconsider precedents and the parties haven't fully briefed it. And I think that's a great way to go about judicial decision making, is just decide what's in front of you.
That's actually a great segue to the cases Judge Pryor is going to talk about. So Judge Pryor is going to talk about the separation of powers, and there's two sets of cases here. The first one, the first two the justice might be accused of writing an opinion in search of a case, because one of them was from just last term, this U.S. versus Seneng Smith case, which was a very strange case where basically an immigration advocate was prosecuted for illegally encouraging aliens to stay in the country in violation of the immigration laws. In the trial court, I believe, the defendant did not claim that the law was void for vagueness. Right? Oh no, I'm sorry, was overbroad. Overbroad. Right. To me, they always seem the same thing anyway. So
They're closely related.
Yeah. Closely related and both being unjustified by the Constitution. Yes. So the Ninth Circuit here. I don't know if there are any Ninth Circuit judges here today. They should be called upon to explain themselves on this and many other items. The Ninth Circuit chose amicus to brief and argue this issue, which had not been raised by the parties. And so the court, 9-0, unanimously sent the case back. But Justice Thomas used the opportunity to write an opinion about whether he thought overbreadth doctrine was actually required by the Constitution. There's a second case Judge Pryor is going to talk about called Johnson versus United States, which is an 8-1 case, Justice Scalia writing, which involved the Armed Career Criminal Act, which said if someone had been convicted of 3 quote-unquote violent felonies, they would be subject to enhanced sentencing. The court said that violent felony was vague. In fact, in the facts of the case, the defendant, one of the felonies was just to have a shotgun, short-barreled shotgun in violation of the law. Justice Thomas used this case as an opportunity to discuss whether the void for vagueness doctrine had any real roots in the Constitution.
Yeah. So what's most interested me in these cases is the difference in approach to the structural Constitution, and particularly to the provision of the Constitution that has been the source of the greatest mischief in the history of constitutional law, the guarantee of due process of law, beginning with Dred Scott. And the difference in the approach to those issues between Justice Scalia and Justice Thomas. And Justice Scalia was often described as the court's greatest defender of the structural Constitution, and it was often described as the originalist justice whose method was most best promoted judicial restraint and most concerned about judicial restraint. And these cases, I think the justice who is better described that way is Justice Thomas. So his concern, well, I'll start with Johnson. So the Armed Career Criminal Act had been, and its residual clause, this definition of what is a violent felony, had come before the Supreme Court on 3 previous occasions, and on 3 previous occasions, the Supreme Court had applied it to crimes committed by offenders who were getting longer sentences, triggering a lengthy mandatory minimum sentence, and on 3 occasions, the Supreme Court had upheld the constitutionality of this statute. But Johnson comes along, and the court, because I guess, feels bedeviled by the continuing problem of applying this statute to different kinds of arguably violent crimes. This Johnson was his crime that was allegedly a violent felony triggering the mandatory minimum penalty was possession of a sawed-off shotgun. Justice Thomas thought it easy to say that the mere possession of that weapon was not itself a violent felony. But he refused to go along with the court's and Justice Scalia's approach of declaring this statute that they had 3 times before upheld as void for vagueness. He criticized the vagueness doctrine as inconsistent with the structural constitution, a disrespect of the legislative power, congressional power, to prohibit certain conduct, and an exercise in judicial power that goes beyond deciding the case before the court and declaring whether it is unconstitutional in all applications. So after Johnson, this provision is in Supreme Court or popular terminology essentially struck down, right? We often say the court strikes down a provision of federal law. Justice Thomas takes issue with that. Courts don't strike down. Courts don't repeal. Courts don't remove provisions from the United States Code. Courts decide cases, and the case before us is an easy one. The case before us is one where this possession of this weapon is not a violent felony within the meaning of the act, but we have no occasion or no right to be saying anything about other cases that are not before us. He then does the same thing with the overbreadth doctrine in the Sinning-Smith case a few years later. And he criticizes the overbreadth doctrine and says, look at what we're doing in the name of due process. Instead of evaluating whether this individual's speech is protected by the First Amendment, we're asking whether this state law and so this has both horizontal and vertical structural restraint concerns for Justice Thomas. Both vagueness and overbreadth doctrines work with respect to both structural restraints. We're asking, well, when in a hypothetical case, this law might be applied to protected speech. And we're not asking whether this individual has a real injury here. We're asking whether it might be problematic in another context. And we're again pretending that we have this power, that's what is essentially a legislative power, to balance certain cost and benefits and to protect certain speech that's not the speech engaged in by the person who is before us. So in a real sense in this area, he's parting ways with Justice Scalia, but here is Justice Thomas, who's the defender of the limits of judicial power, the defender of restraint, and the respecter of the structural constitution.
Great. So I ask you, Judge, and other judges also, is there a consistency to Justice Thomas in these opinions about the attitude towards judicial power? I can't help but notice in the Commerce Clause cases, he's calling for the court to be very active, striking down lots of federal laws, hundreds and hundreds they would be. In your example, Judge Pryor, he's actually claiming courts should step back and be more respectful of Congress and the way its laws, impact free speech or not, or due process or not. And then we're going to talk in a few seconds about his clarion call to really get the courts involved in overseeing the activities of the administrative state. Is there a consistency in his approach to judicial power? Is he a judicial activist?
Can we say those words in Heritage, John? Is that allowed, or am I going to be removed now by security?
I think if I can,
Please.
I think there is a consistency in the sense that if you look at his opinions in the Commerce Clause, in matters like as I mentioned, the Voting Rights Act, the Brady Act, Prince case, the Supremacy Clause cases. He's very concerned about the structure of the 10th Amendment, structural Constitution as the bulwark of liberty. Federalism, separation of powers, all work together theoretically to protect the individual liberties of the people. And part of the potential for abuse arises from Article 3 itself stepping outside of its bounds.
Yeah, I think that's very well said, that the consistent theme is protecting the individual from the state, whether the state be primarily the federal power. There's almost an interesting tension there, I think, in the sense that he certainly has a less capacious view of constitutional rights compared to some of his colleagues, but when he sees a right, he's going to make sure it gets protected all the way, and he's not going to compromise. And I think the fact that he has written individually so many times is a great testament to his independence. And that is something we should all celebrate, the fact that a judge is not making sausage the way a legislator would. He is expressing his view as clearly and politely as he can. You might agree with it, you might disagree with it, but you know that it's his view and it's been carefully thought through.
Naomi, do you want to go ahead, since we're running out of time
Yeah.
with the administrative law cases?
Yeah, we don't have so much time. So maybe I will just talk a bit thematically about some of his more recent cases about the administrative state. Justice Thomas, as has already been said, is of course a committed originalist. He's committed to the original meaning. He has been very focused throughout his career on the text and structure of the Constitution and how that text and structure protects individual liberty. So I think it's entirely in keeping with that much of the focus in some of his separate writings over the past 10 or 15 years has shifted to thinking about how the original meaning of the Constitution is at best in serious tension with the Constitution. So I guess I'll highlight a few things about that. So this is an area in which I think the justices' views have been changing over time. So in 2005, Justice Thomas authored the opinion in a case called Brand X, which had a very deferential view to administrative agencies. In that case, the court Justice Thomas held in his opinion that a court must disregard its prior precedent that was interpreting an ambiguous statute in favor of an agency's later interpretation of that statute. When I taught a class with Justice Thomas on the history and foundations of the administrative state a few years ago, he described his own opinion in Brand X as going to the edge of the abyss. And he said that was when he got there and he peered over into the void and he realized everything had gone too far. And so we've seen, I think, since 2005, him walking back from an expansive view of deference to agencies, which is, of course, about the judicial power. But maybe one of the things that connects his opinions about administrative matters is his real focus on the formal vesting of the three powers of government in three distinct branches with distinct characteristics. And in each of these opinions, he's really tried to give content to, what is the legislative power? What is the core aspect of the legislative power or the executive power, the judicial power? And so we see that in cases in his decision in the Association of American Railroads case, an Amtrak case, he elaborated on the non-delegation principle, which is, of course, all about Article 1, right? What is essential to the legislative power? Why can that power not be delegated to and exercised by executive branch agencies? I think that opinion is incredibly powerful. It was picked up by Justice Gorsuch in his opinion in Gundy, elaborating further on those themes of the non-delegation principle. He has talked about the importance of the executive power in cases like SELA law, where, should independent agencies, to what extent are independent agencies consistent with the vesting of all executive power in the president? Justice Thomas says it is not. I've certainly written extensively in agreement with that view, but there again, you see he's talking about what does this vesting mean? What is essential to the exercise of the executive power? And from his perspective, it means that the president must have the ability to direct and to supervise exercises of executive power, even by the so-called independent agencies. And then I think, all of these cases are, of course, also in part about the judicial power. To what extent can people challenge government actions, agency actions, and in that vein, I think some of his recent standing decisions are very interesting because he's rethinking some of the traditional ways of thinking about standing that Justice Scalia had elaborated in his opinion in Lujan in the 90s. Justice Thomas has gone back to thinking about how the adjudication of private rights is really the essential aspect of what courts are doing when they decide cases and controversies. And I think that is a view that's still developing, but I think it's part of a piece with many of these reconsiderations of the administrative state. And so to the extent, that Justice Thomas is doing this, it's not, each of his opinions, I think also very importantly, is not just about formalism for its own sake, but really about how the structure of the Constitution and the structure of the government serves to further individual liberty. And, to the points about precedent, I do think the discussions about his separate writings about the administrative state are ones in which he has really pushed for overturning precedent about the non-delegation principle, Humphrey's executor with regard to protections for independent agencies. And in that vein, I'll just cite the justice himself, who was citing Justice Story in part. He says, again, in SELA law, he says, "We have a responsibility to examine without fear and revise without reluctance any hasty and crude decision, rather than leaving the character of the law impaired and the beauty and harmony of the American constitutional system destroyed by the perpetuity of error." And so I think some of his most forward-leaning decisions have really been in this context of administrative law.
Great. So we have, in the interest of time, we have about 15 minutes left. I would ask questions from the audience. There's people with microphones. If you raise your hand, why don't you just stand up, say your name, make sure it's a question. Please don't engage on your own personal opinion, issuing your own personal opinions from the bench. So anybody with questions? Right here.
Stand up if you want. So my name's David. This question I think was probably best for Judge Rao. It touches on the Article 2 vesting clause. In Arthrex, Justice Thomas's dissent laments that the court relies on penumbras and emanations of the vesting clause, of the appointments clause. That seemed surprising to me, given his other writings on the vesting clause and the appointments clause. Was it to you? Should I be surprised?
I'm surprised about.
Oh, excuse me.
Oh, yeah, sorry.
To rely on the criticism that the majority in Arthrex was using sort of penumbras and emanations, sort of structural considerations, non-clearly textual considerations.
I think, I think structural considerations are often rooted in the text, right? But sometimes they can maybe maybe to some appearance can look like penumbras and emanations. But I think real structural constitutional law that's focused on the structure through the text is not in that vein.
Other questions? Otherwise, I'm just going to ask like 10 or 20 of them, which you don't want to hear. So please, someone else. Right here in the back here. Yeah, stand up because we can't see you. Oh, there you go.
I'm Jan. Nice, thank you. This is amazing.
Actually, no, we don't want any questions from you. Okay. You always get people in trouble when you ask questions, Jan.
No. Just to kick this off, this whole day off, I guess, we've heard about Justice Thomas and we know about his robust defense of restraint, the structural constitution. But I just want to know, your bottom line. When we talk about 30 years on the court, what is the bottom line? What it means? What is Justice Thomas's legacy?
The elevator pitch, if you would.
No, just to frame that. I think it's important because people have their own views of Justice Thomas, and what is his impact? What's his legacy?
I think he's been the essential ingredient to the case for originalism. So 5 years ago, there was a 25th anniversary celebration at Yale Law School that the Federalist Society and the school sponsored on that occasion. And my focus is on his criminal justice decisions, and I've again focused on the difference between Justice Scalia's approach and Justice Thomas's approach. And it's one thing to have one originalist justice who says, this is how I will approach the Constitution. But when you have a second, then the advocates can no longer ignore it. When the court's closely divided, two justices is, twice as important as one. I look back at one of Justice Scalia's most celebrated, perhaps best originalist opinion, Crawford versus Washington. It was Justice Thomas, though, who a few years earlier suggested that the court's approach to the Confrontation Clause needed to be rethought. And that's what led to the opportunity, that's what motivated counsel then to start making the arguments, to doing the historical research and bringing the Crawford case before the court. And as the more senior justice, Justice Scalia had the opportunity to write the opinion. But it was because of Justice Thomas's separate writing that this was something that needed to be rethought. And in many respects, when they would disagree about originalism, one in the majority, one in the dissent, all the other justices were joining their opinions, but they were all arguing from an originalist perspective. And so I would say his legacy is he's been the essential ingredient in really making originalism matter in a way that no single justice could have.
Well, the only thing I'd say about that, Bill, is that we've got at least 4 members of the current court who consider themselves originalists, and the widespread view of the legal academia, many in politics, the media, and so on, is to ignore them all.
Well, we'll see what happens when you're a lawyer and you have a case in front of those 4.
Or some on the lower courts who have been recently appointed. That's certainly true. I'd characterize his importance in 2 ways, although it might be better to do this at the end of the day rather than now. But the first is, as some left-wing publication headlined a retrospective on him about 3 or 4 years ago, they considered him the most dangerous judge in America because he dared to say things and open Pandora's box about arguments that have been sealed shut for decades, and how dare a judge try to do that. And the worst was, he's influencing many young people nowadays. So I think what he has written has been a very powerful influence in that way. And second, in who he is in the fact that he is very transparent about his background, the hardships he has faced, where he came from, and so on. He is the living embodiment of the promise of liberty in America. And we have racialized so many things. Many of my law clerks are living embodiments of the promise of liberty in America, but because he is a Black man, he is courageous, he is independent, they can't, whatever they say about his jurisprudence, which is highly intellectual, they can't get away from that symbol.
Well, I don't know if I can improve on that. I think my elevator pitch is, Justice Thomas's legacy is courageous fidelity to the Constitution, wherever that may lead him.
I got nothing left after that. No, I think, Bill and Edith summed up well, I think, the jurisprudential legacy. But Jan, I think, let's face it, most of America isn't interested in the things that we're interested in. And most of America doesn't read the things that we read. So I do think that his legacy will be one of the most extraordinary Americans who ever lived, because of the things that Edith and Naomi just said about who he is, where he came from. It is a consummate American story. And as I alluded to earlier, we're all in trouble if Big Brother is going to tell us what to think and what to say. And Justice Thomas's courage in the face of so much challenge and acrimony, standing up for decades and just writing what he thinks. I think, again, whether you agree with him or not, we should all respect that, because that kind of honesty and transparency is something America has been founded on.
I'll just add, if I could, that just take a slight issue with your question, Jan, was that it's not the end of his judicial career.
Yeah.
So he's been on, we're looking back at 30 years, but as you can see, he has charted a very radical approach to judging. It's surprising, actually, how far the court has moved in his direction over that 30 years. If you're scared about influencing the youth and opening Pandora's box, what do you think is going to happen the next 10 years when you might have a workable majority of originalists? I think we're going to see the fruition of the last 30 years in the next 10, and I think it's going to be really remarkable to see how it works out. Let's see what Chief Justice Roberts makes of it. Any questions on this side?
We have one over here.
Okay, great.
Hey, Mike Doherty.
Ooh, sorry. Okay, can you talk about...
Mike up.
Well, last time I got the big back, sorry. Justice Thomas, especially since the passing of Scalia and Chevron deference, and any leadership he's had to finally get that to turn over and have the court actually address something that's been kind of bubbling up.
Yeah, so what do you think about the future of Chevron deference now that Justice Scalia and Justice Ginsburg were both its greatest fans, and they've both left the court, and you have younger justices who are willing to re-examine this? What do you think?
It's all me. I'm sure you all have views about this too. I think one of the things...
Not all of us are on the D.C. circuit.
Yeah.
We not all of us actually have views on this.
No. I think one of the interesting parts of what Justice Thomas has highlighted, which is that in some ways, deference isn't the main problem. The main problem is delegation. So if Congress is going to continue to delegate to agencies incredibly broad authority, judges are always going to have to do something that looks like deference, whether we call it Chevron deference or something else. So I think that if we move away from, if the court starts to have more robust enforcement of the non-delegation principle, that I think will naturally lead to less deference to agencies. But until then, I think some of the labels may change, but I think it's unlikely. If agencies can exercise so much discretion under these broad grants of statutory authority, there's not much for courts to do other than something that looks like deference, unless the agency has really stepped out of its statutory authority. So I think the core of the problem is delegation.
Any thoughts? No? As usual, the DC Circuit bores everybody else in the country to death.
That is so unfair.
I clerked in the DC Circuit, so.
Naomi makes it as interesting as it can be.
One last question. We have about 5 minutes, so I think we have time to take one more question. Come on, this is your chance to ask questions of the judges rather than vice versa.
There's a question over.
Yes, over here. Last question. Great. No, just don't talk. Ask a question. I know. I'm just kidding.
I would just ask that, what do you guys see some of like the issues that will be dealt with in these next 10 years? Like, the next 10 years that you said is going to come to fruition, what do you think are going to be the questions that the court has to deal with?
Point of privilege, we are judges, or ladies and gentlemen, we are not guys. And I just say that because that is the one thing that I will call counsel out on in court every single time.
I think keep in mind, to return to a theme that I was mentioning with respect to Justice Thomas's jurisprudence on the due process clause, we don't set agendas. We decide cases or controversies. So the cases that are going to come before us, sure, we have a steady diet of particular kinds of cases, but a lot of it is dependent on controversies that we can't necessarily foresee. We don't know who's going to control Congress, what kinds of laws they're going to pass, and what kinds of arguments litigants are going to bring before us. And at the end of the day, our power really is a modest power. We're going to decide cases or controversies. And I don't know what the next 10 years brings. I don't think any of us really can. What I do know is that we've got more justices on the Supreme Court who share Justice Thomas's perspective that what really matters is the text and original meaning of the Constitution. And that's going to be a very exciting thing to see as unforeseeable cases or controversies come before us.
Sharpen your question, because I don't think this is going to be covered by the other panels. But one thing we can see coming down the road is big tech and social media. What do you guys think about the potential approaches that in 1 minute, we have 1 minute left in the panel, so
you're asking 4 judges to comment on matters that you're predicting will come before the court, right?
Well, but
that's why you and Richard are so great on that podcast, because no judge could ever do.
What do you think about it, John?
Do we have time? No. Well, just the justice did issue this interesting opinion about what to consider big tech, right? Are they common carriers or not? I'm not asking you to say how you would rule. Just what did you think of his opinion about big tech? Still no takers, huh?
Gotta be kidding.
Jan, help me out. You're much better at this than I am. How do you get judges to talk about stuff they're not allowed to? You seem to be good at it.
Quite a lot today, John.
We don't live in Silicon Valley.
Okay, well, I can't think of a better way to end than seeing judges refuse to answer questions. So please join me in thanking the panelists and the Heritage Foundation.